With that, as a way of offering thanks, I now want to offer thanks to our opening keynote speaker, Judge James L. Robart of the Federal District Court for the Western District of Washington in Seattle. Judge Robart has given enormously of his time here with us today. He just came off of an hour-and-a-half lecture that he delivered for our whole law school community on his experiences and the legal issues surrounding the review of President Trump's executive order imposing travel bans. But what we're really looking forward to here is the opportunity to hear from Judge Robart about his oversight of the Microsoft v. Motorola litigation and his 207-page decision in that case. And if you go and look, as I did, at some of the reaction to the decision that Judge Robart made in Microsoft v. Motorola, these are the kinds of words that are used to describe it. Landmark, desperately needed, roadmap for future disputes, meticulous, and truly impressive. It is something that is truly impressive and has had an impact, and we'll have an opportunity, and looking forward to talking about the impact that it has had and the direction that the law is moving with respect to standard essential patents in the time that we have this afternoon. Judge Robart came to the bench after a distinguished career in legal practice, 32 years serving as the chair of litigation department and managing partner at Lane Powell, a graduate of Whitman College, Georgetown University Law Center, a luminary now in our midst, and I'm very pleased to turn the podium over to Judge James L. Robart.
If you'll indulge a moment of I don't know, personal vanity, I suppose. I spoke in November of last year at a meeting in Southeast Asia. You have never heard a more flowery introduction in your life. The only thing that I was incapable of doing was walking on water, and I was going to take that up next. And it kept building and building and building, and finally the crescendo was this very nice man from Singapore threw his arms open and said, "I give you the father of Fran." I'm looking forward to today's program to find out how the children are doing. The message that I'd like to give you in a few very brief remarks today is Microsoft versus Motorola needs to be placed in context. I said at the time in an interview that was conducted very shortly after the opinion was issued that this was not revolutionary, that it was evolutionary. And I got this kind of blank stare because the journalist didn't understand either of those terms or didn't understand intellectual property law. I'm not sure which. But I truly believe that, and I'm going to take about the first, maybe third to half of the program to tell you why I feel that this is an evolutionary process. So if my slides are in order, I give you the true father of patent infringement and damages, Georgia Pacific. I'm a district court judge. This is the only district court opinion that I think was never reviewed by anyone but is universally applied. You'll note it's 1970, and it had kind of three principal takeaways for it. One, the rather controversial notion out of the United States Code that damages should be adequate to compensate for the infringement. A bit more frontier dwelling was the willing buyer and willing seller rule, although you can trace that back actually into the 1800s. But then the judge really either did us all a huge favor or a huge disservice by coming up with the 15-factor test. I've always been convinced that that was why there was no appellate review of this, was no one wanted to try and deal with 15 factors. I then take you to 2015, actually 2012 for me. My former law clerk, Steve Fortney, and I can barely remember 2012. And the things that I would ask you to take away from Microsoft was, one, I think it's underappreciated that it was brought as a breach of contract case. And as a result, it ends up going to the Ninth Circuit. It doesn't go to the Federal Circuit. And a lot of writings by economists have been to the effect of, what was that cranky old man doing? And the answer is, I was resolving a breach of contract case. I think Steve and I found when we were working on this that Georgia Pacific factors were square pegs, and we were trying to drive them into round holes. And because no one told us we couldn't, we scrapped some and we modified some and we added some. So to the extent that that's revolutionary, I don't think it is. I think it's just evolutionary. We were dealing with a different factual context, and you needed to come up with a slightly different method. The next thing up there is royalty stacking and holdup, much discussed, I think definitively kind of dealt with in Erickson v. D-Link. But I put up there the other thing I think that's important because of recent developments, and that is we computed a range and not a point. And that was due to the fact that if you were in different factual situations, you might reach different results. And then I think the thing that was the last thing we say in the first 40 pages, which is about all you need to read of it. The rest is a patent by patent description and analysis, and then some concluding statements about how we're going to apply this in the context of the case. These seemed self-evident. First, the court should consider the importance of the patent portfolio to the standard. We were dealing with a patent portfolio. We weren't dealing with a single patent. Considering both the proportion of all the patents essential to the standard and the technical contribution of the patent portfolio to the standard as a whole. I've never had enough nerve to do this, but if I asked you to raise your hands, how many people agree with that? I would be surprised if anyone disagrees with it. Second, a court should consider the importance of the patent portfolio as a whole to the alleged infringer's accused products. And then third, the court should examine other licenses to determine a RAND rate. Those are not groundbreaking. Those are simply statements trying to put us into the context of a FRAND patent. So I'm happy to be the father of FRAND, but it got there before I did. Because I was doing my own slides, I could do anything I want. I'll take you to what I think is the next most important, next meaning chronological, and that's Judge Holderman's innovatio decision. I will tell you, having been on the bench for 15 years, or working on my 15th year, anytime the opinion begins, plaintiff and patent owner has sued numerous hotels, coffee shops, restaurants, supermarkets, bowling alleys, hair salons, and other commercial users of the internet technology. You know how the opinion's going to come out. I truly love Jim Halderman, but you'd have to be the chief judge of the Northern District of Illinois and an incredibly respected IP judge to begin your opinion with that statement. Secondly, he engaged in a very fact-intensive, case-by-case evidentiary approach. And in that, he used the Microsoft methodology. But he made a number of modifications, and when we've talked about this, he said, I don't know how you're going to feel about my modifying your formula. And I said, I'm delighted. We didn't see this as 15 factors that were going to be used in every case. We thought that we made it clear that it was to be fact-intensive. And if you have different facts, you're going to use a slightly different approach. So in that case, Judge Holdeman held that there was not a range, but there was a precise RAND rate that he could apply. He plunged headlong into the smallest saleable patent practicing unit, and much to the joy of economists forever, lacking comparable licenses, he opted for a top-down approach. I was asked this morning if I would define top-down and bottom-up, and I said no. The Federal Circuit has to do that, which they by and large did in Erickson v. D-Link. Remember, I go up to the Ninth Circuit, and they can't spell intellectual property. And I'm sure that the Federal Circuit went, if we don't get to own the whole thing, we're not even going to stick our finger into it. So Erickson versus D-Link, coming out of the Eastern District of Texas, has really kind of the roadmap of where we are these days. District court must instruct the jury only on factors that are relevant. Well, that implicitly approves something I did, but I really think was kind of just common sense. But now they've said it so all practitioners in the audience can do it. District court should make clear that any royalty award must be based on the incremental value of the invention, not the value of the standard as a whole, or any increased value the patented feature gains from its inclusion in the standard. That's black letter law. It's sit down now, so we know we need to follow that. The entire market value rule discussion, I frankly found a little confusing. It almost looked like in order to reach an opinion, they had to trade horses here. It is not one or the other, it's both, a substantive legal rule and an evidentiary principle. Interesting. And then finally it holds, kind of in keeping with his first point, there's no unique modified version of the Georgia-Pacific factors for RAND encumbered patents. And as I said in that first point, the big dog has spoken, so we should all pay attention to it now. I spend a fair amount of time in Europe where they're still trying to figure out what I meant in English. This is the English view. I suspect, given the nature of this audience, most of you know it. This is Justice Brizz's take on this issue. He's got a lot of really wonderful things in there, some of which is that Britain, which had just left the common market, is now going to opine on what French law is. That's an unusual situation to be in. Thank you. But probably where we start to really significantly differ is that as opposed to a range, Judge Brizz says, or Justice Brizz says, there is a royalty rate, one, given to any set of SEPs and circumstances. I will just tell you, I think that's contrary to U.S. law. I know that Justice Brizz has been invited to a whole bunch of seminars in the United States, promised business class tickets, and apparently he's holding out for first class tickets because he's turned all of those down. He and I have kind of this agreement that if he ever does come, I'm going to go to the same conference and we're going to, be on opposite ends of the podium, and it will look like the presidential debates or something. It would be fun. Number two, neither breach of contract nor an antitrust claim will succeed unless royalty offer is significantly above the true FRAND rate, I suspect you're going to hear about that later today because I see the creeping influence of antitrust law, competition law coming into this area. Rather controversially to me, FRAND licenses for global users are global licenses and not limited to a single jurisdiction. Depending on how that one gets fleshed out, that's either a principle we all agree with. You know, if you've taken a license, you can use it anywhere you do business. On the other hand, it's written in a manner to suggest that anyone else who's in a particular location, even though you didn't know you were applying Ethiopian law, you've got a global license and a global rate. And then back to this question of competition, a non-discrimination violation requires a distortion to competition. That I'm not sure is as applicable to us because we tend to be practicing mostly in the United States. I'm told, and I know we have some antitrust specialists here, that that's a significant holding in the context of a more global competitive market. But what I would stress from this is, you know, it really is a situation where you're evolving standards. And part of that evolving standard is what happens in Europe, what happens in other parts of the European continent. You know, and this is a well-respected justice. I don't think he has the last word on this case. There have been some subsequent decisions that have chopped away at a couple of portions of it. But, you know, he fired right out there with his take on how you deal with FRAND and RAND. And then very, very recently is the TCL versus Erickson, our old friend Erickson. I think has a speaker here today. This was an issue that I didn't have enough courage to tackle, and it wasn't in my case. But it's how do you do, I mean, one of the things I hear when I go to meetings often, usually in the bar afterwards is, you know, Judge, it was nice you spent all that time doing that opinion, but in the real world, we do cross-licensing agreements, and it's on portfolio basis. And I say, well, you know, that wasn't the issue that was before me, but thank you for that bit of advice. This is Judge Selma trying to deal with some of the issues that come into portfolio valuations. First, he opts for a top-down approach that gives Unwired Planet, Apple, Japan versus Samsung, and Innovato a 3-2 lead over bottom-up, which is both Microsoft and D-Link. Although the Federal Circuit opinion, I'm not sure you can tell if it's top-up, bottom-up, or top-down. Now you're going to get my opinion. I didn't do the disclaimer that these are my opinions and you should pay no attention to them. I think that, you know, what Judge Selma was trying to say is that Penn Law is very fact-specific, and as a result, don't assume that because he held it in TCL that it's going to apply forever or it would apply to a slightly different set of facts. Something that I'm very happy to see Brother Selma do was he basically said, in, I think, response to the criticisms from numerous economists and Judge Posner, that you're never going to get the precision that you know, the economists are seeking in connection with these FRAND rates. You know, for heaven's sakes, they're a range under my view of the world. And, you know, it's just impossible to come down to the absolute penny and say this is what it is, unless you're in some situation where you're, you know, discussing a chip and you've got one patent of a limited number of patents in that chip. So I would submit to you that as opposed to saying what was the judge talking about in TCL, you ought to view it as one more step in that evolutionary process that I think is important here. In the remainder of my time, I'm going to give you three completely generous and unsupportable suggestions of gazing into the future. Immediately after Microsoft was issued, you began to hear more and more noise from the European Competition Commission. You already had in the United States the FTC actions, you had the ETSI's pronouncements. You know, now you've got unwired patents that tries to set out what sounds to me almost like a safe harbor. I was sitting in a bar. It's kind of a common thread to my remarks. But I was sitting in a bar after a panel one day, and after about 2 hours of having some economists explain to me, I completely understood how antitrust law and competition law and intellectual property law were completely compatible. I woke up the next morning with a slight hangover and a firm belief that that was nonsense. I think by definition, intellectual property law gives you a legalized monopoly, and it's very hard to reconcile it with the notion of competition law, which has as a stated purpose the elimination of monopolies. So I think, you know, we're going to continue to need guidance in that area, and I would humbly suggest to you that the guidance that's already been promulgated by at least the FTC leaves a fair amount of wiggle room for people to take different points of view. For those of you who don't know, the IEEE came out with what in effect is a revision of their FRAND regulations. Took some extremely bold stances in there, partly about injunctions. I think that we're going to see the emergence of the standard-setting organizations as of greater importance in this area. I think that should be viewed by you as positive, because I think you have greater control over those standard-setting organizations than you do, for example, over the antitrust division of the Department of Justice. At least in the case of Etsy, they were also willing to boldly go where no one had gone before, in that they have established some rules that can be read as allowing greater coordination, I'll use that word, in pricing, which has always been the principal no-no that most standard-setting organizations engaged in saying, we won't touch any aspects of that. So that, I think, is a change and is going to be an area where you should be looking for further development. And finally, I couldn't help but including this. When I went to Germany shortly after the Microsoft opinion came out, I was detested, and I was told that I was stupid and an American. In German minds, those two were redundant. You know, and how could I not recognize that German patent law was perfect? And, you know, German patent law was the Orange Book, and the Orange Book is based on an aggressive use of injunctions. Now you try and reconcile ITSE's current stance. And you know, if you read the dialogue that's taking place in the United States, the inability to obtain an injunction under the eBay factors, I think the last article I read said had decreased the value of patents by 90%. Now that article was paid for by someone who had a large patent portfolio, but it was a well-respected individual. And they contended that they had done a scientific study and produced this 90% number. I've talked in my taped remarks this morning. I think injunctions are still available. You'll have to watch the video to see the areas where I think you can get them. But I think if you can show to the judge that you've engaged in good faith negotiation and the other side hasn't engaged in good faith negotiation, Yeah, injunctions are still available. But I would suggest that really injunctive relief is another one of these three areas where in this evolutionary process, we're going to see some further development. And frankly, it wouldn't surprise me to see the Federal Circuit take another run at injunctions, paying homage to eBay and then ignoring it, because it is a unique and somewhat different circumstance in the intellectual property realm. So they told me that I didn't have to take questions, so I won't. Instead, you're going to get to hear from people who will tell you about the health and welfare of the children. Thank you very much.